My name is Clarence Mon. I'm doing this video for my PowerPoint for my criminal law class. Just going to go over these slides that I've made for the presentation. We start off or whatever with our discussion of the differences between criminal and civil law and lawsuits, and what the difference in those are. Criminal prosecution has to do with crimes, and usually in the course of having a case is the only one that can have. Normally, we'll have a jury. Most civil cases will be handled mainly by just a judge. So, and a lot of civil suits are going to deal with properties, divorces, stuff to do with money that does not involve an actual crime. It's just a dispute between people. As moving on, we go into the differences between procedural and substantive due process. The difference in procedural refers to methods and manner of which the law is enforced. It is the procedure in which we hear it condemns. Substantive requires that the law itself, not merely the procedures by which the law would be enforced, is reasonable and just. Then we go in to talk about the differences and the similarities between common law and the modern jurisprudence. And the common law, English common law, started back in the 1800s, where it was a set of laws that they made, the judges at that time made due to the customs and the way things were back then for the people. We carried that over and incorporated that into the modern laws that we have now, which consists of our modern day judicial system. Throughout that, we've modernized it and actually kind of made it our own. Then we go into the differences of whatever the Constitution, constitutional laws, and Florida statutes. The Constitution's the main part of that is going to be the 14th Amendment, which says that people are not allowed to have their property taken, their rights, violated without justable cause, without a police officer can't come in to search their house without due process or a search warrant, and they're not going to have that. So you can't violate people's rights just because you want to. Then we go into ex post facto laws, which are laws that may have been they're new laws that apply to people, but they may have been doing things prior to the law wasn't there and it wasn't considered legal. A big one for that is prohibition. Before there was prohibition, alcohol and all that was legal. Then they came out with prohibition, which is new law. So all the people that had alcohol, they weren't guilty of a crime, but they had to get rid of it. The people that produced it and such after makes it to where it was illegal. Same with back in our old days, there was cocaine, marijuana, some forms of LSD were not considered illegal. So if people hadn't used them during that time, it wouldn't have been a criminal act. After they made them a controlled substance and illegal, that's when it became, if somebody had it after that fact, then it was considered a crime. Burden of proof. A big part of burden of proof is going to fall on both the prosecution and the defense. The prosecution is going to have to prove through evidence and witness statements and things that the defendant is guilty of the crime they committed. And on the other side, it's going to be the defense attorney's job to give or take away that burden of proof and prove that their defendant or their client is innocent of the crime that they're being charged with. Then we go into elements of crimes. You have concurrence, causation, mens rea. It's the criminal intent. Was the person actually coherent when they did it? Did they know what they were doing? They have to have the desire and the ability and the opportunity to do so. If they didn't have that, then there's a good chance that they probably didn't mean to commit the crime, but they can also be found guilty for it anyway. We go into criminal defenses. There are actually about 9 actual criminal defenses that are mainly used out there. You have affirmative defense, the insanity defense, which has to be proven that the person was actually dealing with a mental disease or defect at the time the crime was actually committed, not that they just all of a sudden popped up with it in the courtroom. Coercion and duress, that's they were coerced or threatened to do the crime. So they were actually didn't want to do it, but they had no other choice because of the fact they're being threatened, or somebody in their family or something they care about was threatened. Abandonment and withdrawal, it's the person had the intent and the purpose to actually commit the crime, but before it actually happened, they decided not to do it. They decided to withdraw out of it or abandon the crime itself. Self-defense, that's a big one. In the process of somebody attacking you or trying to rob you or something, you are a concealed weapons carrier, you shoot the person. In that case, or whatever, it's self-defense that you were protecting yourself. Consent, that is that possibly that the person that committed the crime had consent from the victim in order to do something. We had a big deal with that here in Florida with the assisted suicides. So intoxication, that's one that in the course of a crime being committed, the person was intoxicated on either alcohol or drugs or something like that, took their state of mind out and made it to where they may or may not have been very or completely coherent in what they were doing. So they're still going to probably be guilty of a crime, but they might not. It'll take out one of the elements of the actual what makes up a crime. And then statute of limitations. The prosecuting attorneys have a certain time in order they have to charge a defendant with a crime. If they go past that time, then the statute of limitations has gone up, and at that point, most of the time, or a judge should throw out the case and dismiss the charges. I've learned a lot while being in this class. It's actually very interesting. I hope to take this information I've learned from this class on with me in my further careers, which I'm working on getting in with the Sheriff's Department right now. Would like to eventually use my knowledge that I have to move myself up into possibly becoming a detective or something someday. So, in which case, or whatever, appreciated being in this class, and I hope to have you again as a professor. Thank you.